proprietor and there is no entity, if anything goes wrong in that business and you get sued, there is no containment mechanism. So the judgment that someone may get against you can easily and will bleed over to all of your personal assets that are not otherwise protected. Now, obviously in Florida, we enjoy a very strong homestead protection. Our qualified money, like our 401ks and our IRAs, are largely protected. Cash value of life insurance and certain annuity products. So there are some protections already built in, but the money you have sitting in your bank account, if you own more than one piece of real property, all of those can be on the chopping block if something happens in a sole proprietor business where you have no entity. So if we're going to set up an entity, we want to make sure we set up the right one. Do we want to set up an LLC? Do we want to set up a partnership? Do we want to set up a actual corporation, either taxed as a C corporation or an S corporation? Many small business owners always gravitate, and I think rightly so, towards the S corporation status for taxability because you have that single layer of taxation. However, for real property investors, whether you're buying and flipping or buying and holding, there may be an advantage to having a C corporation, even though you otherwise fit the definition and could apply for S corporation status. So we can walk our clients through when a C corporation might be more beneficial. Even though you may eat another layer of taxes, there may be overall advantages to setting it up that way. So once we decide to set up an entity and the tax structure, we then want to look at anonymity planning. And what we mean by that is, do you care that people know that you own this business? Now, certain professional services, doctors, lawyers, CPAs, you are your business. Everybody knows that you are the business. So there's really no need to hide or shadow your ownership or involvement in the business. However, we have several clients recently. One gentleman is, he's pretty visible in his church group and holds himself out to be, a really, I use the wrong words there, take the high road kind of guy. Well, he had an opportunity to invest in a nightclub and a bar that was a very good investment opportunity for him. So when he came to us, he said, listen, I want to keep my reputation up within my community and my church group, but this is a really good business opportunity that I don't personally have a moral problem with, but the optics may not be great in the circles I run in. So we were able to have him as a principal investor and owner of an institution that he may not want other people to know that he is an owner, and mask his involvement. And the way that we do that quite often is by opening multiple entities in multiple states. So for instance, Florida requires that all owners of corporations or all members of LLCs be listed on SunBiz. So many of you have looked up your own name or your own company or looked up another company to see who the owners are. And so that's a little bit of a downfall. There is no mechanism for shielding membership in an LLC in the state of Florida. If you type in your name and you have an interest, it's going to show up. So how do we prevent that from happening? Well, we typically do that through a Wyoming LLC. We open a Wyoming LLC because, unlike Florida, the Wyoming division of corporations does not require the members be disclosed. The only person that needs to be disclosed in a Wyoming entity is what's called the organizer. The organizer is kind of more akin to a registered agent. The organizer doesn't need to own any piece of the business, doesn't need to be a member, doesn't need to have any control of the business. And typically myself or Jason will be the organizer. So what that looks like is someone wants to look up, I'll pick on Quinn. Someone wants to look up Quinn and see what she owns as far as business entities. Well, if she owns more than one LLC in the state of Florida or whatever she owns, they type in Quinn's name to SunBiz, they're going to see everything that is associated with her name. However, if we had set up an anonymity structure, then what they're going to see is that her name shows up nowhere in SunBiz. So their first reaction would be, well, she doesn't own any business. But even if they know the business name and they're trying to get to who the owner is, then they're going to look up the business name. The only member they're going to see on SunBiz is a Wyoming LLC. So they're going to say, all right, nice try. I'll go to Wyoming, and I will then find out who owns the Wyoming corporation. But when they go to Wyoming, all they see is Michelangelo, Mortellaro, organizer. So even if they wanted to sue that company, they're going to call me and say, hey, will you accept service of process because we're suing your company? And I will politely inform them, it's not my company. It never was my company. I was a hired gun to organize the company. And their next question will be, well, then you need to tell us who the owners are so we can sue them. And my response will be polite but stern of, I'm sorry, I cannot give you that information because of attorney-client privilege. I'm not authorized to disclose the owners, so you're going to have to find them another way. And it really puts roadblocks and, as we call it, layers to the onion to make you as cloaked as you want to be and make it more difficult for plaintiffs and their attorneys to get the ball rolling on a lawsuit. Because let's be honest, plaintiffs' attorneys get paid, especially on personal injury type stuff. They get paid on what they collect, not on what they get a judgment for. So if out of the gate, we're making it difficult for them to even identify the parties, the first thing that attorney knows is they're working with a sophisticated defendant who's already taken proactive steps to make the plaintiff's job difficult. And most likely those attorneys are looking for low-hanging fruit. They're looking for the people that didn't organize things. They're looking for people that have multiple rental properties in their own name. So they're thinking, boy, if I can get a judgment, I can take all these properties. And when they're realizing they're dealing with a sophisticated defendant, quite often the juice isn't worth the squeeze. They will turn down the case and they will deprive the plaintiff a meaningful representation to go after that business owner. So rental property is another big one. We have a client right now who's rebuilding. Unfortunately, he had a situation where when he had a good year at his business, he would buy a rental property. And over the course of several years, he had amassed over 20 pieces of rental property, all of them in his own name. He knew that at some point he should probably do something to protect them, but he never got around to it. His 17-year-old son borrows the BMW one night to go to a high school party. He gets a call at 3 o'clock in the morning. His son's being charged with DUI manslaughter. The automobile insurance he had, he thought was adequate. He had a $250,500 base policy with $1 million umbrella. For most people, that's plenty. However, what he ended up with was a $12.5 million judgment against him personally as the owner of the vehicle. And once they exhausted all of the resources from the auto insurance, the umbrella policy, they said, hey, judge, by the way, a quick record search has identified 22 pieces of rental property that have no mortgages. We'd like them. And the judge signed over $8 million of rental property to the plaintiff. That could have easily been resolved in his favor and limited his liability to only his insurance proceeds by creating entities, creating anonymity structures. And then furthermore, I have created a trust for individuals who have new drivers or bad drivers in their house, where we can take the vehicle, title it in an irrevocable trust that only owns the vehicle. And then any accidents that vehicle is involved in, there's really only two defendants. There's the 17-year-old son who has no money and there's no reason to go after a judgment on he or she. And you can sue the vehicle owner, which is a trust that only owns now a wrecked vehicle. So we can bifurcate and isolate the parent's assets from potential liability from their young driver making bad choices. So that's another product that we offer, very inexpensive, and it just makes a lot of sense for people that want to limit their liability. So another thing is the rental property owners, staying on that course, is you probably have tenants. You may from time to time need to evict your tenant. You may not want your tenant to jump on the property appraiser's office and find out where you live. So the option to create the structure that owns the entity that owns your rental property to be anonymous, where they don't even know who it is. And if you're the one dealing with your tenants, as many people do that don't have a property manager, you don't need to tell them you own it. You can just tell them you're the property manager, and they probably won't be mad at you for evicting them. They're going to think it was that terrible owner that did that to them, but they can't find out who the owner is. Another thing that we do is we create a bubble around each item that has risk. So if you have 10 rental properties, I can't tell you how many people have one LLC and they put all 10 rental properties in the LLC. Well, that's better than nothing, because they may not be able to get to your personal assets, assuming that you've been keeping up with your corporate formalities. But if something blows up and one of those rental properties catches fire from a risk perspective, then all of the other properties are also fair game for that judgment. And so I appreciate that people don't want to overspend and overcomplicate on entities, but we really look at risk in the form of fire hazard. And we want to make sure, if you think of like a cruise ship, they're strategically designed to be able to isolate things like fire. Fires on boats are very bad, especially if they're in the middle of the ocean. So if we have the opportunity to isolate the kitchen, isolate the engine room. So if there's a fire in the kitchen, it doesn't spread to all the guest rooms and sink the boat. We can isolate it to where it started. We can deprive it of oxygen and it will burn itself out. We may not have a kitchen, but the rest of the boat is intact. And if you think of your assets as the boat floating around in the ocean, and you have 1, 2, 10 rental properties, 1, 2, 10 entities that you're doing business, we want to isolate all of those and be able to starve out a fire if it happens and not let it spread to your other assets. Losing any amount of assets is never a good thing. But if you have 10 properties and one is at risk and the other 9 are still producing, life isn't as bad as it would have been otherwise. So we want to make sure that your entities are set up. Operating agreements, very important. People don't appreciate that. They have articles of incorporation they got on FundBiz or their CPA gave them, but they don't appreciate the power of the operating agreement and how that can also lend to asset protection. Another thing that we always talk about with our clients is business exit and transition planning, because at some point you may not want to run your business anymore. We want to make sure that it is set up to extract the maximum amount of equity if you ever want to step down, sell it, have one of your employees take it over. We talk about key man insurance. If you have partners, partnership agreements are huge. We call them, business prenuptials or business postnuptial agreements. We think of a business partnership as a potential for a divorce. If that happens, we're going to be much better off if we worked with the partners and created a plan for what if one day we want to dismantle this business, whether someone dies, someone gets sick, or someone's just unhappy and doesn't want to be my business partner anymore. What does that look like? I promise you, it is much easier and less problematic when two partners who are not at odds and who are having a good relationship say, listen, we know the world is the world. What if you get sick and I'm doing all the work now and you're taking half the profits and you're not contributing? Well, not fair to you, wouldn't be fair to me. Let's sit down and talk about how we would handle that situation. You set it up, you write the playbook, and if you need it, you have it. If you don't need it, great, it's there. The final piece where I think most business owners fall short is that over 82% of business owners have no estate plan whatsoever. And if they do, they may have an estate planning attorney that drafted their will or trust, and they may have a business law attorney that set up their entities. There's a really good chance those attorneys have never spoken. So time and time again, we see businesses, small businesses, having to go through the probate process. Going through that probate process normally shuts the business down for 6 to 12 months. So think of your own business. What if no one's writing payroll, no one's paying rent, no one's paying the phone bill? What is your business going to be worth 6 to 12 months after you die when the doors are shut, no one's answering the phone, no one's servicing your clients? I promise you, it's probably a fraction of what it would be if there were a continuity plan embedded into your estate plan, that the day something happens to you, disability, incapacity, death, there is a plan. We have consistency in ownership and management, availability to bank accounts to pay payroll and keep the lights on, and being able to then sell a business, if we decide to sell it, at a fair market value as a going concern with goodwill versus something that's been shuttered for 6 to 12 months. Classic example right now, if anybody's in the Tampa area, down around International Plaza, the Lucky Dill. That has been sitting in probate now for, I think, a couple of years. The gentleman, I want to say, was in his late 40s, early 50s, had a heart attack and died, had nothing planned for that business. So after all of the time and effort he got trying to just get it open and running and making money, it's now sitting there dormant, making nothing and getting deeper in debt. That debt's going against his estate. And eventually, I would venture to guess that it's going to just wash out and his family will have zero economic benefit from all of that hard work and putting together that business. So it really is a holistic approach. And Fortress is the only law firm and the only business consulting group owned by attorneys that is supported by two law firms that work together, that create the structures, deal with the taxes, isolate the risk, deal with succession and exit transition planning, and then ultimately plan for what if you pass away and everything needs to go through probate, or avoid probate through something like a trust structure. So that's kind of the soup to nuts of Fortress. Many people ask the question, well, what level of assets do you have to be a Fortress client? The reality is, whatever you have is important to you, whether it's $100,000 or $100 million. It's important to you. It's what you've earned, you've worked for, and this is your baby. So our job is to integrate an appropriate asset protection plan to protect whatever you have. Big or small, doesn't matter. We can use, on the personal side, Florida asset protection trusts, which we don't use often. We can use Nevada domestic asset protection trusts, which provide a lot more protection than Florida. And for people that really want the belt and suspenders approach, we can do offshore trusts where your money is controlled from the U.S., but it actually resides outside the U.S. jurisdiction, so that no matter what your judgment looks like, there's no judge in the country that can force you to give up the assets, because they are housed in a jurisdiction that does not have full faith and credit with the U.S. and doesn't have to apply and abide by any U.S. court orders. So start to finish on personal and business asset protection is what we do. What questions do you have?
I have one quick one, referencing back to the Lucky Dill, and I think he was also part owner in Prohibition Kitchen in Dunedin, and I think his mom still owns the Lucky Dill up in Palm Harbor, I guess.
I believe his mom is the Palm Harbor.
Right. So let's use that as an example. How much would it cost, and how long would it have taken him, talking about the International Plaza one, in round numbers, to have protected himself in that business, do you think?
10 grand.
And how long, what's the time frame, do you think, to do that?
3 or 4 weeks.
So probably money well spent, I would think.
Yeah, I mean, the numbers that I think I read in the papers, he's somewhere, his estate is somewhere in the $4 to $6 million invested in that. It's the open debt. We're not talking about the value of the building and the improvements. We're talking about the creditors coming after his estate. That probably would have been vastly mitigated if it was doing as well as it certainly deserved to do as an open business, making a boatload of money. I'm sure that that his family would be in a much better position than they are now, with arguably what's probably going to be an insolvency case where there's nothing that's going to come out of his estate that's going to go to his family, because the creditors are so large. If we would have structured it properly, the creditors would not have had access to his personal assets going through his estate, and even having a succession plan. I mean, obviously I don't know the family, so I'm shooting from the hip here, but his mom does a really good job with the Palm Harbor one. He could have really just in the operating agreement said, listen, if I get hit by a bus, my shares go to my mom. She now can run the business. And I would venture to guess it would be up and running and making as much money as Palm Harbor makes, and as busy as that Palm Harbor location. So the business might have still been making money, paying its debt, and not have an insolvency issue within the entity itself.
Question from the chat room: can the real estate be found during a divorce through a forensic accountant?
So divorce is a fun thing. Divorce courts, family law courts, are courts of equity, not really courts of law. Really what that means is judges have the flexibility to do what they want. So the answer is, when it comes to family law, your best protections are going to be a prenuptial or postnuptial agreement. If you don't have that, you are going to be put under oath. You are going to be asked, what do you own? Where is it located? Provide financials. And we would never recommend to a client to be dishonest while under oath. So the answer is, for divorces, there are certain things you can do. Typically, forensic accountants will go back only about 2 years. So we tell our clients, if you see trouble on the horizon, we can start investing in some offshore companies. We can start moving money, not in a fraudulent way, but I'll just use the example. What if you have a good friend or a family member and you want to set up a corporation offshore and you want to hire your brother or your best friend as a key employee and you want to overpay them for what they do? Well, there's nothing wrong with that. And if that business takes a loss because you're overpaying employees over the last few years, they're going to look at the numbers and just say, well, it's a business that has lost money. And if that person then saves up some money and wants to help you out in your time of need, all of those things are potentially appropriate, as long as they're not done for the purpose, and certainly not done after any actions are instituted, either divorce or other plaintiff actions. So if you move stuff out more than 2 years from the filing, there is a good chance the forensic accountants, unless they're really motivated, will miss those transactions. But it's certainly not optimal to be trying to tinker with the family law judges, because even if they identify it, even if, as I said, jurisdictionally they can't get to it, and they say, okay, well, this Bob has $1 million in the Cook Islands and we can't touch it, but his wife wants half. All we're going to do is identify all Bob's other assets we can get our hands on. We're going to give wife an extra $500,000 of those assets to accommodate for the ones we couldn't get a hold of. So there's a little diminishing returns when it comes to family law. However, courts of law versus courts of equity, Bob gets sued for a business deal that went bad, or Bob has one too many drinks at happy hour and hurt somebody or kill someone and gets a judgment over his liability limits on his auto policy and umbrella policy. Those judges don't have the option to tinker with other assets as long as we have protected them. And so those plaintiffs will be limited to whatever the insurance premiums or the insurance policies might cover. And there's a lot of things in your life that aren't covered by insurance. People think, I have homeowners and I have business insurance and I have this insurance and umbrellas. Well, you have a couple drinks and you get in a bar fight and knock somebody over and they hit their head and die. There's no insurance company that's going to say, oh yeah, well, we're going to cover that for you. You're on your own from dollar one. So insurance is great. I think we should buy as much insurance as they'll sell us in most instances, but we do need to realize there are things that happen in life that are not covered by insurance, or the insurance will never be enough to cover the full danger and the full risk. So that's where we engage in asset protection planning. It really also gives us leverage in negotiating. When we have a client that has, $1 million offshore and they get a $5 million judgment against them, we can have that frank conversation with the plaintiff's attorney to say, listen, I know you want $5 million, but we'll give you $200,000 a day cash. You go away, we settle this. Or you could chase us around the world for the next 3 or 4 years and probably not see a penny. So bird in the hand or two in the bush, however that saying goes. What do you want to do? And remember, plaintiff's attorneys are motivated by collection. So they may tell their client, listen, man, I know it's not $5 million, but $200,000 a day is good, because that attorney's going to make $66,000 of the $200,000, and he or she will put money in their pocket, versus having to hire an attorney in the Cook Islands and institute a lawsuit there, and then hire another attorney in Nevis or Belize and fight it there and never see a penny for years and have all this money going out, also knowing they're probably never going to collect a penny. Those attorneys are not going to be motivated to fight that fight. They're going to be motivated to take whatever you offer them.
Is the Grand Cayman still a place to go with your money like it used to be?
Not as much. We still, work with companies in Switzerland and Grand Cayman because they do have secure banking institutions and they're safe. But as far as the old days of having a Swiss bank account that doesn't have your name on it, those days are gone. There is a paper trail. Forensic accountants are very good. They're going to see a wire going out. They're going to know it went somewhere, and that somewhere doesn't really matter. They're going to show the judge where it went, and the judge is going to know what you did. And so if it's structured in a way where the judge can't pull it back or get to it, that's fine. But when you're dealing with the Switzerlands of the world, there's treaties, there's things with the U.S. where they don't want to be adversarial to the U.S. for a bunch of reasons, whereas small places like Cook Islands and Nevis, they don't care. They're making money on these structures, and whether the U.S. likes them or doesn't like them doesn't really matter in the big picture.
So if somebody has 10 LLCs, and all in their name, the example you used before, and they wanted to move them to, say, was it the Wyoming that doesn't have that? Yeah. Is there a paper
Correct.
trail for that, or do you need to do it right out of the gate?
Your best bet is to do it out of the gate, because there's no, from day one, even if they went back through your previous filings, they're not going to see anybody's name except for the Wyoming. However, in practice, what many people will do is set up a single Wyoming. So you don't need 10 Wyoming holding companies. You can have one Wyoming holding company holding all of your 10 LLCs in the state of Florida. Now, once we do that, if someone types your name into Sunbiz, it will no longer pop. But if someone goes into your Florida LLC and looks at it, your name still won't pop. But if they're smart enough to then go back through previous filings and through previous renewals and the original organization, they will see your name. However, that doesn't mean that you didn't sell your LLC to another entity in Wyoming, but it does still associate your name with it. It's better than nothing. And if you already have a going concern and you don't want to retool new entities from scratch, it's not terrible to just drop a Wyoming LLC as a holding company. Plus, Wyoming has really great protections for charging orders. And anybody interested in that, we can have a conversation offline on how charging order protection can be good. But basically, no one can foreclose your interest in the business. All they can do is take your distribution. But Wyoming allows us to make distributions, turn them on, turn them off, make them to other people. So effectively, your creditors can never pull a distribution from your Wyoming LLC.
Anybody else in the room have questions?
I do.
Oh, yeah, we got one in the room here.
Hey, Susan Luca with Cadence Bank. First off, out of the gate, I have two current clients right now that I need to get referred to you, so I'll have to get your information. It just so happens they have current needs for your particular expertise right now, and we've been talking about it. So thank you for your presentation. I found it very informative. Second, I have an 18-year-old, soon to be 19-year-old, and I just find this to be brilliant about putting his car in a trust. So two parts on that. Why wouldn't everyone put their cars in a trust? And how does the insurance work on that?
So insurance can be tricky because many insurers will see a vehicle owned by a trust as a business entity. And if anybody ever has business insurance on their vehicles, it's 3 to 4 times as expensive as personal lines. However, I have worked a deal with State Farm, and I'm sure there's other insurers, but I've just worked a deal with State Farm. They've read my trust. They are willing to insure it as a personal lines policy, so we don't get whacked on the business policy premiums. And to your first question of why doesn't everybody do it, for most people who are responsible, having a good quality underlying base policy and an umbrella typically makes a lot of sense, and there's no need to go into a trust. But young drivers are just so much more exposed than the average experienced driver that the trust probably doesn't make a lot of sense for the average person. But the statistics, I think, are, within 6 months, most new drivers get in an accident, and it's usually their fault. And depending on the severity of that accident, it might be worth the ounce of prevention to not have to deal with the pound of cure after the fact.
And Susan, just because you brought that up, and Michelangelo, I want to double down on that. And if I'm missing something, please piggyback off me. So when I work with clients who have young kids, there's always this stereotype that if you have a trust, you're worth millions and millions, and it's only for millionaires. Anyone can have a trust. And I'm working with a young client right now, husband and wife, where they've got a 6-month-old daughter, and I've asked them, do they have a trust set up for her? God forbid they both get in a car crash. Tomorrow they die. Who's managing money for that child? And they kind of looked at each other and didn't have the answer. Anyone can set up a trust, and that's going to protect those assets for those children. And not just that, it's if you don't want those kids to have, whether it's 500,000 or a couple million, even 100,000 at 18 years old, you can set up what age you want to distribute that to your children. So anyone can have a trust. There's always that connotation that, oh, well, I'm not rich enough to have one. Do it and protect those assets for your loved ones.
I couldn't agree more. I tell people all the time that the more money you have, the more advantageous the trust may be on things like probate fees when you're talking about the 3% attorney fee and the personal representative fees. However, I've done a ton of trusts for little Polk County or Pasco County folks that own a mobile home and a little piece of land, it's still cheaper than going through probate. And when you're dealing with minor children, when you're dealing with special needs beneficiaries, it only makes sense. There's something called the UTMA, or the Uniform Transfers to Minors Act, depending on the state you live in. Typically, if more than $15,000 of value is going to someone under age 18, they need to have a guardianship set up to manage that money for them. There's more attorney's fees, more court costs, more filing fees, and that minor needs to be under the care of an attorney until they reach the magic age. So we can save a lot of time, a lot of effort. Anybody that has minor children or any sort of special needs beneficiaries, you're really missing out by not getting educated on how a trust might help you and your family.
And not just that, just do you really want the grandparents to manage that money? Where if they can't manage their own, you want a professional to do that when you pass away. And that's what the trust does for you.
Well, and here's a big one, divorce families. You know, I can't tell you, I think in thousands of divorced families that I've worked with, I can count on one hand the number of single parents that say, if I die, I'm totally fine with my ex getting all of my money to take care of our children. It just, for whatever reason, and probably for good reasons, money is often issues that cause divorces and marital problems. And when there's an ex involved, you probably don't want them to have the money. So I totally agree. We can go with a professional fiduciary. We can go with a bank. We can go with a trust company. Or if you want to choose someone that you trust, you can use them too. But just when you have blended families, another important piece of just talking about the estate plan, because what people don't realize is husband and wife may have everything jointly titled. They may be each other's beneficiaries on life insurance and 401ks, and jointly own the house and jointly own the cars. Well, spouse one dies, spouse two doesn't see a problem. There's no probate, jointly owned, beneficiaries, everything rolls to spouse two. Spouse two dies without a will. Where does the money go? It goes to spouse two's children. Spouse number one's children get nothing. And that's probably never the result of a blended family, but they don't realize it because they don't take the time to get educated on what happens. And if spouse one is, let's just say, the person who brought the majority of assets into that second marriage, and then he or she's children get completely cut out arbitrarily because their mom or dad happened to die first, and the second spouse who had nothing coming into the relationship, their kids get the windfall. I don't think many people or anybody logically would look at that and say, yeah, that makes a lot of sense. Let's just throw it up in the wind, and whoever happens to die second, their kids get all the money, and the other one just gets left out in the cold. So very important that we have those conversations with blended families.
So it happens all the time, though. Sadly.
Absolutely. Absolutely. So that's what we're here for, is we're here to educate people on the risk, and nothing that we do is a hard sell. You don't have to sell this stuff. All you have to do is tell people where their risks are. And if they're logical, they're going to want to mitigate those risks. Then we look at budget and we look at a bunch of other things of whether it makes sense. Is the juice worth the squeeze? But having that initial conversation on where are your risks and what happens if you bury your head in the sand and do nothing, that's where the magic is.
Any other questions from the room? Some great stuff. Obviously, I need to update my dating profile. I don't really care what you like. I need to know if you have a trust, probably. I don't care if you like long walks on the beach, but I just need to update, see if you have a trust, because that's probably the more important question. And do you have kids as beneficiaries? Yeah. So.
We'll have you submit a financial affidavit before our first date. It'll be awesome.
Yeah, swear testimony. Any other questions in the room? I was a little bit late starting the recording, but I did start recording it. So Quinn popped on. This could be scary.
I was just going to interject, Doug. I think you need a little bit more than that on your dating profile.
Shots fired from the peanut gallery.
All right, let me use Quinn real quick here. So now, some great stuff.
Anyone can. I appreciate the opportunity. Anybody can find my information, mortellarolaw.com or fortressassetprotection.com. Both of those will get you to me. Doesn't matter which number you call into, it's still getting to me, and we'll get you set up. All consultations are no charge. For our Cadence Bank person, I am actually a Cadence customer, and we have actually the majority of our accounts at Cadence. So I'd love the opportunity to help build a referral relationship with my own bank.
Hey, Michelangelo. John Benincasa here. How's your little one
Hey,
doing?
John, what's going on, buddy?
I don't talk to you in a while. How's the little one doing?
Which little one? They're now 2, 4, and 6.
The 2-year-old.
He's a 2-year-old.
Okay.
Good to see you, man. I hope you're doing well.
You too. Same here.
All right, sounds good. And Michelangelo is a chamber member, so if you don't have his information, you can always go to the website and find that information as well. So plenty of ways to get to him. He's right down the road. He's right by Stumpy's and the Firearms Academy and all that. So always great information. It's a lot to wrap your head around and absorb, but I think I probably need to, I'm a single guy with a house and a 401k. I probably need to figure out if something does happen to me, what happens to it. So
yeah, we always invite we always invite you in for the what if I get hit by the beer truck conversation, and that will result in you wanting to do something. It may not need to be elaborate based on your situation. It may not need to be expensive at all. It may be as simple as, let's say you're a renter and you have 401k and you have investments and you have bank accounts. You might just get by with putting beneficiaries on everything, or POD, TOD at your bank, and you don't need a trust, you don't need a will, you don't need anything. The reality is more people are probably somewhat more complex than that, but there are strategies that we can give you that cost you zero in legal fees or anything else that can be a meaningful probate avoidance tool.
yeah, it's also, Quinn and I both obviously sell real estate, and I've gone through some probates, and hindsight is 2020. Had they done certain things, it might have been quite a bit easier for the family, and there might have been more money available at the end of the day had they done things slightly differently. So
I have a video on my website you might want to check out. It's called Probate is for Suckers, and I say that tongue in cheek as I now have 82 probates running in my office concurrently. But the only people that make out in probate are the attorneys, and it's avoidable, and it's always unnecessary unless you just fail to plan.
Awesome. Maybe we'll share that to the chamber page too as well. So if there's no other questions, I know he's wants to get that seatbelt off and go wherever he's going. I'm not exactly sure. So
get to my office, try to make $1.
Yeah, exactly. We appreciate it. Thank you so much for
All right, guys.
being part of the economic development. We'll see you guys.
Thank you for the opportunity.
Thanks.
Bye-bye.